welcome everyone. Thank you for coming. My name is Karolina Iwańska. I represent the European Center for Not-for-Profit Law, a human rights NGO based in The Hague, where I work at the intersection of civic freedoms and technology. And up until recently, I worked at Panopticon Foundation, that some of you might know. And I will have the pleasure of moderating this panel about the ups and downs of complaints handling under the GDPR. So like everything during this conference, a very hot and challenging subject. I do have a suspicion that we might focus a bit more on the downs, but the ambition of this panel is not only to take stock of where we are now, but most importantly to start a constructive discussion about the ways forward with a particular focus on cross-border complaints and the one-stop shop mechanism. And to do this, we are joined today by three wonderful speakers who represent a whole spectrum of perspectives and experiences when it comes to complaints handling. So first we have Magierska, there in the middle, a PhD researcher at the European University Institute. She investigates cooperation between national data protection authorities, focusing on cross-border and cross-sectorial cooperation mechanisms. Second, I'm pleased to welcome Talus, who is the Data Protection Ombudsman in Finland. She was appointed for this position in 2020, having previously served as a Deputy Data Protection Ombudsman, as well as a Senior Advisor at the Finnish Ministry of Justice. And last but not least, we have Bastien Querrec, who is a member of the litigation team at La Quadrature du Net, a French NGO that promotes and defends fundamental rights in the digital era, and a PhD student at Université Grenoble-Alpes, working on public sector use of algorithmic decisions and their impacts on human rights. So we don't have a lot of time, so let's dive straight in, and I will first ask each of our speakers some questions to kick off the discussion. So please be brief and limit yourselves to 3-4 minutes. I know it's difficult, but we want to have enough time also for responding to each other and questions from the audience. So Maria, let me start with you. You have co-authored a very interesting report published this week, actually available there in the booth of the Data Protection Scholars Network, which examines how DPAs in a number of EU countries facilitate or not the submission of complaints. And could you try to briefly summarize your findings as well as the current landscape of complaints handling? What could be improved and how?
Yeah, thanks so much, Karolina, and thanks so much for having me here. So the research Karolina is speaking about, we did it with the Data Protection Scholars Network for Access Now, and is available here at this conference. You can get the first printed version. And yeah, so I will try to briefly recapitulate our main findings. So the question that we've asked was, what happens when we file a complaint, when we want to file a complaint under the GDPR, and what information can we find on the DPA's website? What happens next, and what are the main practices? So, and I'll just start. I will go to our legal and practical findings, but first, maybe three main issues that are very visible there. It's first of all, it's lack of it's immense fragmentation, and I think it will be something that will appear here. We will be hearing a lot during this conference, anyways. So, fragmentation of administrative laws that creates a burden when handling a complaint. Secondly, it's lack of information. And thirdly, it's lack of transparency. And these are three main issues that appear in every aspect that we investigated in this research that we have. So going to this legal aspect. So we looked on the current legal framework that we have under the GDPR. And as you know, in GDPR, it's pretty straightforward. We have the right to lodge a complaint before the DPA of our main place of residence, place of work, or the place of alleged infringement. And that's pretty straightforward, but in the details, it's quite different how the DPAs understand it. So there's no definition of complaint, there's no definition of what does it mean to handle a complaint, and there's no definition of what does it mean to inform the complainant about the proceedings. So that creates a huge problem for data subjects, because very often, and I'm looking forward to hear more from Bastien about it, the information, so it's technically possible for the DPA to just answer within 3 months about how your proceedings look like, but the information that we can get is very different. So I'm looking forward to hearing more about it later. So that's the first thing. Then is the question of amicable settlements. So there's no such thing in the text of GDPR. Amicable settlements appear only in the recitals and only in the context of the local exception. And yet, it seems as a growing thing for the DPAs. There is whole new internal guidelines on this. And it seems as we are moving to this direction, which is have its pros and cons, but it's not transparent why, and only some DPAs use this method, others not, others aren't necessarily prepared to do this. So it's a huge there are huge discrepancies there. And then again, we have the problem with Article 77 and 79 overlapping, so the judicial proceedings and DPA's proceedings, like who should prevail. As well as the thing of, again, internet guidelines, that we have such things as internet guidelines that aren't published and they aren't publicly available. And the ones that I'm talking about, we have access to them only thanks to the civil society. So that's, again, the question of transparency. When it comes on the ground, so we look on the websites of the DPAs and checked what are the information on how to handle a complaint and how to file a complaint there. And we found very huge differences. So there are DPAs where we have this large button on the website where it says, click submit the complaint. And we have the websites where there is no information whatsoever about how to handle a complaint, how to file a complaint, and what happens next. So even if it's quite easy to file the complaint, it's almost, there is no information for data subject what happens next, what should they expect, which creates a problem because many of them don't know about one-stop shop. And it's already a very complicated mechanism. So it might be surprising for data subject to learn that if you file a complaint in your country, it suddenly ends up in Ireland with completely different procedures, completely different also the timeline of these procedures, and just might be disappointing. And it creates huge discrepancies. Also the rise that we have and the effectiveness of the enforcement of the GDPR. Next, we don't have any information on Article 80, so the fact that we can, that the organizations can file the complaints on behalf of the data subject. So information that sometimes appear on the websites of the DPAs, but usually we don't know about it. And we can only, essentially DPAs, most of them seems to assume that when we go to the website of the DPA, we already know what that we have this right to file a complaint. And then finally, this issue of how electronic complaints handling looks like. And electronic complaint, I mean by electronic forms, is very crucial for cross-border complaints filing. It's almost impossible on the current terms in some of the DPAs. So to file a complaint, sorry, I'm just wrapping up because it's very important. And just to close, so it's almost impossible sometimes to file a complaint via online as a non-national of the DPA. Because, for example, electronic forms require electronic signatures or some other form of identification that is visible on the website, only in one country. So it's very hard to do this, not to mention different standards and different ways of adding supporting evidence. And yeah, it's practically very difficult to do this. So just maybe to sum up, we have this huge issue with fragmentation, with lack of transparency, and I'm happy to talk about it more later, and lack of information. So,
thank you, Maria. So it seems like there's a lot of chaos, and I wanted to turn to Anu to hear about your experiences. I have taken the liberty to check the EDPB website, and according to which the Finnish Data Protection Ombudsman has so far issued one final one-stop shop decision as a lead authority, and has acted as a concerned authority in 52 already resolved cases. And based on your experiences, would you be able to pinpoint what makes some complaint handling processes effective and others frustrating or difficult? And if you could change, one specific thing tomorrow, what would that be?
Oh, thank you, Karolina. To start with, I'd like to point out that if we go back a couple of years or even a bit more, the one-stop shop and the new way for the DPAs to cooperate and to make binding decisions, as it was laid down by the GDPR, was actually quite groundbreaking. The system shifted some of the national DPA's decision-making powers onto the EDPB level, while at the same time having kept the national DPAs very strongly involved. And now, of course, when we have this type of very new decision-making mechanism, there has been also some challenges, but I do think that it's important to keep this starting point in mind. It was an entirely new way of making decisions involving the member state data protection authorities, while the final decisions were were made on the EDPB level, or in yes, and well, indeed we have faced some challenges. Well, I wouldn't. Well, I don't know how Finland placed in your report, but I would not say that it has been impossible for the complainant to file the complaints. The increase of the incoming cases when the GDPR entered into force was well, they nearly tripled. So for me, it seems like there is definitely a way to find out how to file a complaint. Clearly, it can always be streamlined and find ways to have it more consistent throughout the whole, well, in all the member states. So on national level, the greatest challenges we met were the increasing number of incoming cases, and this caused a backlog, which we are now luckily slightly, little by little, coming over. But then in cross-border cases, I think that one of the greatest challenges were to find out. Well, the DPAs we worked quite hard to find out and to find a way how to put together 27 plus 3 administrative procedural rules to make it work. I think that we have now actually tackled many of these challenges. Like I said, on national level, we are now on the better side of the backlog. This is not only due to the new resources; it has also taken us to think through our existing procedures and to make our procedures more efficient. And actually, for instance, for the data breach notifications, we have put place an entirely new way to handling these cases, and it has now shown to be quite effective. On the EDPB level, we have worked to find ways to reconcile different administrative rules. And like you heard in the morning session, we made quite strong commitment in Vienna to work even further in that same path to make the cross-border case handling more efficient. I think that it's not entirely in the hands of the EDPB to find out or to find out solutions to find to find out how to reconcile the national administrative rules, and here the EDPB did give or the member states. Authorities did give a statement in Vienna. But actually at the moment I see that the biggest danger for the fragmentation is the big five. These proposals partly overlap with the GDPR, and when this is the case, if the supervisory powers of these legislative acts are not in the same hands as the supervision of the GDPR, I think that there is a great danger of different interpretation of data protection legislation, not only in the European level, but also on national level in the member states. And from my point of view, I actually see that as the greatest challenge for fragmentation in the future.
Thank you very much for painting this picture and future challenges. Bastien, I wanted to turn to you now to ask you about a case that you are responsible for starting against Amazon that has led to the highest GDPR fine to date, 746 million euros, issued by the DPA in Luxembourg in 2021. And you represented more than 10,000 people in this complaint as an organization. Could you briefly describe the biggest obstacles in this process for you as a public interest organization and to the people who you also represented? And what would have had to be different to have made your experience better?
Thank you for the invitation. And yes, in 2018, La Quadrature du Net wanted to test the new GDPR procedure of Article 80. So we started group actions before the French DPA, CNIL. Our goal was not to have cross-border cases, but more to test this new procedure and to test the notion of consent. So we represented more than 10,000 people to try to make this consent efficiency for Google, Apple, Facebook, Amazon, and Microsoft, or LinkedIn. Our complaints were based on public elements. It's the terms of services of those companies. So no need to extensively process the case. It was really simple. And for the case of Amazon, it's quite interesting because for between 2018 and 2021, it was an absolute silence, a perfect silence from both the French DPA and the Luxembourgish DPA. And by the press, we learned that a draft of the sanction was ready, and by the press, we learned that Amazon has been sanctioned. So we never learn any element in this procedure, nor from the Luxembourg or from France. And it's quite interesting because as plaintiffs, and as a lot of plaintiffs, we are out of the procedure. We are not part of this. We are just people that fill in a form, and that's all. So I believe that there are positive elements in this case, because in France, at least, the procedure is quite simple. We just sent a register letter with notice of receipt. It offers a legal proof that the complaint has been filed. The representation of people is very simple in France, but on the negative aspects, the dialogue between DPAs is a nightmare. Aside Amazon, we have currently 4 ongoing cases. And for example, about Google, after 3 years in Ireland, the DPC's position has changed, and now it considers that the leading authority is not the DPC, but is the CNIL in France. So after 3 years of absolutely nothing, the DPC sent back our complaint in France, and now the CNIL asks for the EDPB opinion about who is the leading authority. So the dialogue between DPAs is a nightmare. Almost all of our complaints are in the maze of European procedures. Each authority has its own procedure, its own interpretation. For example, the DPC has not the same interpretation of Article 80 than the CNIL. In terms of at what point we have to check the identity of the people we represent. In France, we just offer the possibility to fill in a form. We do not check the identity of the plaintiffs, because we believe that Article 80 is more a political aspect than nothing else. And there is also another very bad element on the Amazon case, is that we are not sure about the legality of the silence asked to France by the Luxembourgish authority. Today, we do not have the final sanction. We know that this sanction has been done, but we do not have it. In France, the CNIL closed our case with a letter summarizing the sanction, but not with the sanction itself. So we are not sure about this legality of the silence. And another negative element, not directly related to cross-border cases, but in France, the CNIL is very reluctant to investigate on topics when there is no formal complaint. So it's very hard for an NGO like Quadrature to be on every topic, to complain about every negative element we saw, and the position of CNIL not to investigate cases when there is no complaint is one of the biggest negative elements.
Okay. Thank you very much. Would you like to respond, Anu, or there you go.
If I may.
We can already start the discussion part
Yes.
of our panel. That's the point. If
Yes.
you disagree or have comments, go ahead.
Yeah, well, I would just like to point out, like I said in the beginning of my, that, like I said, the one-stop shop mechanism, it's an entirely new way to make decisions. It was never pre-tested. So now if we are focusing what has happened during the past 3 years, I think we are a little bit off the track, because we have made actually quite many decisions to make the cross-border handling more efficient, and there is also a very clear commitment to take this even further.
May I just ask, what were those measures that you are describing specifically to help a little bit solve this problem?
Well, we have, of course, for instance, we have the guidelines on the amicable settlement to find out, well, first we needed to identify the differences in different member states, and even that is quite a extensive process, as you can see. And then we have agreed how to handle or how to approach these cases. And I'd like to also point out that for me it seems like it is rather the question of strategic, the files which have strategic importance, which are now here on the table, not so much the issues of an average citizen filing a complaint at the DPA. For instance, in our case, the citizens whose cases have been handled in the one-stop shop mechanism are normally actually quite pleased that they can handle, they can have the dialogue with us, not with some other DPA in another member state with a language which they not necessarily know. So I think that we also need to recognize that there are success with the one-stop shop. Now we are actually talking about the cases which have strategic importance here. So I think that this is an important difference to be made when we assess how the one-stop shop has functioned.
Mm-hmm. So something that has come up in I think everybody's interventions was that there is a lack of kind of clarity for data subjects, what to expect from this process. There are discrepancies between administrative procedures in different countries, and there are efforts to reconcile them. But as you mentioned, who is, what if they cannot be reconciled? What if some countries, have such different administrative procedures that it will still make this whole process inconsistent? And I wondered whether, you see those, attempts at, solving these very specific issues. Is it more a short-term solution that is going to, help with some immediate problems, or whether is it more a cosmetic fix that we are applying now? It might take some time, but we actually need more ambitious kind of look at the entire one-stop shop mechanism, perhaps. It's a kind of speculative question a little bit, but I just wanted to ask whether more clarity for data subjects and in terms of how different procedures look like, will it be sufficient to make actually handling of complaints effective from the perspective of the data subject? Because, for me, if I find out that in Luxembourg I will not be informed about the final decision, so I cannot really appeal it, while Amazon can, what difference does it make for me to know it, right? I want for this procedure to be changed, and I cannot influence that from France. So I wondered, what would you see as short-term solutions that could work in a short perspective, or whether they will be sufficient, or whether we need something more? Maria, would you like to start?
Yeah, thanks so much for this question, and also for these points that we just heard, because that's the point, essentially. You mentioned these very good examples of people that are happy with one-stop shop, or you mentioned also the French CNIL and the the good practices that it had, but it's is the thing that in Finland it would work, but then you have then we have these other countries which have completely different standards. And as a data subject from I don't know Poland, for example, I will have different experience probably, and we can't avoid this. We can't avoid like. Full fragmentation will always be present in the EU, because that's how it's built. But we need to, as long as we can address it, we can try to fix it, at least in the context of the GDPR. Although I'm certain that full harmonization is not possible, and it's not something that would be also perfect. So about the question of the clarity, I think it's immense. Like even to know that if you complain against Facebook in Poland, it will go to Ireland. Even that knowledge, I think it's already something for the data subject, just to know what to expect. Because now, if I would go to the website of the Polish DPA, I will just find here information that the proceeding will be carried out in line with the Polish administrative procedure, and that's it. That's only one sentence, and that's really like, and it's the case of the Polish DPA, because then we would have other DPAs that have more detailed information. So the standards are really diverse. So I think one of the good things that we can do, at least that it would be great if the DPAs do this as the EDPB. So first of all, the guidelines, but also compliance with the guidelines. So that's another thing, to what extent DPAs comply with the guidelines that they introduce, because there are also differences in that. But even existing and this general willingness that DPAs really see the problem. It's not like they're shunning from it. It's really good. And apart from the guidelines, it's clear information, maybe some register of the number of complaints, because one issue that we actually had here during our research was even to count the complaints, because each DPA defines them differently, and it's almost impossible to track and to compare. Like at this moment, only the number of fines is some ground of comparing the effectiveness of the DPAs, but it's only fines. It's only one measure that the DPAs are using. Apart from that, it's very hard to establish effectiveness between the DPAs, like even judge it, because everyone counts the complaints differently. So it would be great to have some independent, maybe the register that actually clearly somehow gathers this information. And apart from that, also this information about Article 80 organizations that are eligible to comply, because I think that would be, especially in this context of cross-border procedures, it would be essential. The role of the civic society would be essential, because that's what it's how, like they know how to handle these complaints, and they are able to help data subjects. So.
What if they become, the new DPAs overloaded with the backlog? But we will worry about it later. Would anybody want to directly respond to this? Go ahead, Bastien.
In terms of short-term possibilities, I think that the European Commission has to take this problem seriously and maybe to start infringement procedure. Maybe against Ireland, because it's not acceptable that for a simple complaint filled in 2018, 4 years ago, we still do not have any news, any sanction. Today, almost all of the American tech is in Ireland for tax optimization. So all of these companies are in the field of the DPC. And today, one country, Ireland, is in charge of all those big tech. And it's a problem that the Irish DPA is not working. It's not acceptable that today Microsoft has not been sanctioned. The same for Apple. Google, the case is back in France. We should do the next stage. That is the infringement procedure.
Mm-hmm. Anu, please go ahead.
Thank you. Just to comment on the short-term solutions, I think that the issue of the transparency of the procedure is actually quite good, and something that can be fixed on short term. This is actually something that we have identified in my office to work on, and it's not only to make the process more transparent on the data subjects, but also on the controllers. And this is actually this is an easy fix, so to say. When it comes to cases of strategic importance, one of the outcomes of the Vienna conference was that we will yearly identify a number of cross-border cases with strategic importance, with an action plan. And this was one of the outcomes of the Vienna conference. Then, if we are talking about Article 80, which Maria just pointed out, this is then on the more of the side of issues which are not really on the hands of the data protection authorities. And lastly, I must say on the behalf of our Irish colleagues that they are actually working quite hard. so it's not only it's not a question of being reluctant to work, but they also have an immense amount of cases to handle.
So we can maybe zoom in on that, because I think it's a recurring problem of this bottleneck of strategic cases with one lead supervisory authority. And I wonder what is the solution to this. So I understand there are certain task forces, for instance, for those cases of strategic importance within, for example, the EDPB, or just increased cooperation. But still, it does rely on the capacity of the lead supervisory authority, assisted by other authorities, to issue a decision, and it's not happening yet. So I wanted to ask you to assess this sort of tactic, whether this is going to, whether we just need to wait a couple of months to see the effects of this action plan, or whether this is, in your view, kind of doomed to fail if we still have one authority dealing with a lot of cases of strategic importance. Can we increase the role, for example, of joint kind of operations of national DPAs to take over some cases, of the DDPP to take over some cases, or maybe think about some sort of centralized processing unit for those cases of strategic importance. So just to think about how do we kind of work with this bottleneck, whether we expect that these kind of action plan based on the existing mechanism is going to work in the near future, in the far future, or not at all. I wonder what do you think?
Well, we just came out with the Vienna Declaration. I think it's a bit premature now to assess whether it will fail. My expectations is certainly that it will work, because I know that all the data protection authorities are quite committed to make the one-stop shop and the cross-border case handling to work.
How can we help this commitment? So I understand the intent is there. Is there anything that anybody in the space can do, civil society, the Commission, EDPB, EDPS, to help with kind of translate this commitment into practice that you haven't included in the action plan, perhaps?
Well, I don't have a list for tasks now, but this is certainly something that it's good to look at and to think about how the work could actually be maybe spread around.
Mm-hmm. Would others want to also come on this point?
Yeah. So thanks. So maybe correct me if I'm wrong. The Vienna Declaration is I think it's excellent. Excellent that it happened, and it's a proof that DPAs want to cooperate. But if I remember, it's not. It's on cooperating in cross-border cases, but outside of one-stop shop mechanism, if I remember correctly. Yes. And
no, they're both.
They're both. But
yes.
What I meant, it's what's the issue now. It's also that in the GDPR there are these mechanisms that aren't used yet, like joint investigations, and I think no one so far triggered it. And also, it's very difficult to trigger when it comes to dispute resolution and urgent procedures. This threshold to actually to EDPB to sort of approve this procedure, like it happened with the WhatsApp case, is very high. Also, because there is this plenty of voluntary and understandably, there are also needed mechanisms such as voluntary mutual assistance, instead of the regular one, that in the end causes this bottleneck on the DPC, because it's not bound by the mechanism of the GDPR this way. So maybe this is also the opportunity for the DPAs to use this mechanism, and maybe don't shun from using them in the context of such authorities that sometimes, I think 4 years of handling, we will really have complaints that are still pending from 4 years and were filed on 25th May 4 years ago. So I think there's still plenty of room to also within the GDPR to ensure the effectiveness of that. But I think that Vienna Declaration is an excellent step towards it. But
Can I ask a follow-up question on the urgency procedures and joint operations? Why they haven't been used? Is it a political matter that you don't want to, initiate an urgent procedure against your colleague in the EDPB, or do you really have to get super frustrated with somebody to do that? Or is it a political thing, or is it a practical thing? Is it also not clear how this would work, or this one case that we had kind of cleared the path a little bit, and we could expect some more in the future? What do you think? Go ahead, Adam.
Well, our hands have been quite full with the current procedure and to make the current cross-border mechanism to work. So I think that there are still mechanisms in the GDPR which can be better profited, and I'm fairly certain that this is an opinion which is shared by my colleagues.
Bastien, would you like to also come in on the issues of bottleneck, kind of trying to push these cases towards resolution?
It's very difficult because a lot of the negative and the positive elements are because of the national laws. For example, in Luxembourg, the silence of the DPA is because of the national law. It's not a topic of EU law, so it's hard to use the EU level to improve all of this mechanism. But I still think that at least when there is informal cooperation between DPAs, we should have more transparency, because in this case, there is no national law that enforce kind of omerta. For example, in the case of Amazon, we know that the CNIL and the CNPD, the Luxembourgish DPA, work together. It's a good thing that they help each other. But today we know that the CNIL has the final sanction, but it refused to send it to us because of the procedure in Luxembourg. And we believe that the CNIL has not to comply with a foreign procedure, but today we are in kind of dead end because of all those national laws on what we cannot enforce. We cannot, as a French NGO, we cannot. We do not have the resources to go before the Luxembourg lawmaker to ask it to improve the procedure, and we are focused on France. So I believe that it's a dead end and a major difficulty.
So to come back to this question of lifting those cases of strategic importance to some other body, is this, obviously something that would require changing the existing mechanisms, but is this, an unnecessary reinvention of the wheel, that, we should focus on these solutions that we have identified already and push them through and in some time assess whether they're working or not and have this discussion again, or whether you think, for Anna, I understood it was a preliminary discussion of whether this would be neither or not, but what do others think on increasing the role, for example, of the EDPB, or setting up a completely new authority, like some of the proposals that Anu mentioned as a challenge, like that DSA, DMA, they have centralized enforcement as part of it. Could we take inspiration from those? Is this the time for already having these discussions, or do you think that we should stick with what we have now and not try to kind of reinvent the wheel there?
Today, the current situation is very strange. So I agree with you that maybe the EDPB has a key role to play in the next years. So of course, because we have DPAs that are failing to do their job, we have to find another authority. And maybe that the EDPB is one of the possible solutions. But we also have to fix the DPAs that are failing. So we do not have to find a new perfect solution and to let the current situation to be worse and not to fix them. We have to play on both sides.
Mm-hmm. Anu, you also wanted to come back?
Yeah, I was just about to say that I think it is a way too early to engage in a discussion about future solutions. We just came out with the Vienna Declaration. This was just a month and a half ago. Now we need to give some time to see how these amendments will work in practice. So I think that it's very premature to engage in a discussion of something else, maybe.
Mm-hmm. And when would be that time? You know, how much patience should we get ready for? Anu, Maria, is there a deadline?
Well, I don't think that. Well, you cannot really set a deadline for this type of thing. You see whether it will work or not, and then we heard on the morning panel. I think that it might take years to have a new system on place and to function as it should. So.
Yeah, I think that maybe it's too early to discuss the future and to revolutionize the system completely, but I think that's the good moment to actually have this discussion at least starting, because as you mentioned, we have all this new regulation coming up soon. We already had a huge discussion and whole conference on how the GDPR is not working, and we'll soon face new authorities that will also be underfunded. We also have all these issues that we are now talking about. And also there is this moment with this new regulation opportunity to talk about what is the good enforcement model in handling cases that are connected to the flow of data that is always cross-border, always entails tackling with different national procedures. So I think even this conference is a great opportunity to do this, at least ask these questions, like how later the EDPB will interact with other authorities that will handling the other regulations, and maybe some of them probably will be the DPAs, with new competences, and some of them may become telecommunication authorities, and some of them will be completely new ones. And there is a huge risk that we will face regulatory chaos soon. Maybe I sound pessimistic. Maybe that won't be the case, but I think we need to at least have this discussion now and maybe already think of possible solutions. And again, about the question of centralization, because it's then the next question would be if we need EU digital regulator or something like this form. It's maybe an open question that it's still like I don't have the answer for that now, but maybe we just need to have at some point this discussion. Thanks.
And on that note, I think I would like to open the floor to our audience. There should be a mic somewhere. I can see one person there. Could we pass the mic to? Okay, 1, 2, 3. Please keep your question brief so that we have time to take as many questions as possible.
Yes, hello. Thank you for this panel, which was very interesting. My name is Paul Dehaye. I'm the director of a company called Estia AI. If I take the sum of the two, the session before and this one, we heard Max Schrems mention that if he wants to go forum shopping, Austria is particularly helpful in terms of cost. It's a good place to have the data subject. But I think there is two layers of forum shopping. There is also the possibility of choosing which data controller you want to attack. So that's more relevant to an NGO who is trying to do an action. And that is particularly interesting in some situations, because if you combine this, so try to follow, with joint controllership, that allows completely circumventing the one-stop shop mechanism. So you could have an Austrian data subject addressing, for instance, a data request to a French data controller for data that is jointly controlled with, let's take Facebook, an example. And so this complaint handling is all happening between Austria and France, but really concerns data that is passed on to an Irish player, for instance. So this joint controllership will be extremely difficult for data protection authorities to manage. And I was wondering if they were anticipating civil society figuring out some of those mechanisms for forum shopping.
Would you like anybody in specific to answer the question? Anna, could you? Or?
The question about joint controllership, and if I understood correctly, how we would then handle the case of joint controllerships in the cross-border mechanism, and how we would how we would communicate. No. Okay.
So yes and no. It would involve a cross-border mechanism, but between two states that are different than the joint controllership states that are involved.
Yes, by so far defining the LSA in such cases have for the biggest part actually work quite well between the dialogue between different supervisory authorities. But there is only one LSA in such cases,
Yes.
lead supervisory authority.
Yes. But has it been handling joint controllership cases? I guess that's the main question.
Well, at least there are some in a process.
Bastien, do you want to also go?
My answer will be disappointing because I have a feedback from the perspective of an NGO. I'm not in the head of DPAs. I don't know what are their problems, what they have to do. What we saw is that the current procedure does not work. We want to have rights. We are talking about fundamental rights. It's not a matter of comfortable right. It's a fundamental right, the right to privacy. And today we saw that we cannot enforce it. So whatever the process is, we want to have effective procedure. It can be with strong DPAs, it can be with one European authority, it can be with a mix between all of them. In the perspective of la Quadrature du Net, I don't have an opinion. We just want to have something that works, and today nothing works.
Thank you. We have a question here, and then in the back there.
Thank you very much, David Erdos from the University of Cambridge. I'm conscious that we've spoken mainly about the one-stop shop, actually, which could also be own initiative issues which crop up, rather than directly on the role of complaints or whether complaints play a useful role in data protection generally. And I'm wondering whether people could comment on whether there isn't a very different culture amongst different data protection authorities, actually, as to whether complaints actually are useful. Some process hundreds of complaints, maybe thousands a year, formally. Others, you would be hard-pressed to see them taking any formal action ever. And, I know with Brexit, the UK is no longer, but it has UK GDPR. They're quite positive about the fact that 3/4 of their resources go to engagement activities, not to enforcement. Now, I think that that's wrong, but that is the culture. And therefore, without confronting the fact that these regulators are at completely different spaces in terms of what they think their role is, how can we find solutions? So if people could sort of comment more on that issue about the cultural differences here.
Maria, would you like to take this question in light of the report? Is this something that you also looked at?
Yeah, so the question of the different cultures of enforcement, it's something that we won't escape, and it's visible not only in the data protection, it's basically almost every field of EU law that deals with this question. And what's so specific about the GDPR here, that we at least have some mechanism, at least we have some starting point on how to deal with it later. And the question of usefulness of complaints. So in some countries, it's like some DPAs won't act without a complaint. So they won't act just on initiative. They prefer to have complaints, for example. So it's like these differences are very huge, and same is with the standards. Maybe it would be interesting to have some collection actions probably in the future, and that would be a solution again, and again more engagement from the civic, even more engagement of the civic society here, and the NGOs playing that part. But as we heard on the previous panel, is also the question of the capacity of the sole NGO to deal with that. And And I was maybe also want to maybe add to this previous question on forum shopping and joint controllership, that even this question proves that something is wrong here, because we are talking about circumventing the one-stop shop and figuring out which DPA would be good to file a complaint with. It shouldn't be an issue at all. Like we should discuss how to do strategic litigation to make controllers enforce make controllers comply with the GDPR, and think how with issues such as legitimate interest and all of it. It's already pending because we are just discussing the mechanism that is not working. For me, that is the most crucial issue here. That's the problem.
I guess this was something that came up at the first panel with Max Schrem's intervention about what's the default. Is the default, compliance, or is the default non-compliance? And it's up to, making controllers compliant through complaints that are not handled. So we talk a lot about. In other conversations on the DSA as well, we talk about the importance of defaults, right? So is this something that we could improve in the? I guess that's also what your question was about. Is this something that how we could improve the default in those countries where the default is not, something that we would like? Is it public campaigning? Is it some strategic litigation? Is it infringement actions? So I guess we have like a number of tools that we could use to this end. I just wanted to check how many questions there are. So there's one there. Okay, so we can take this question.
So just to add a word, very short. I think that one of the role of the EDPB is to create this common culture. I think there is something to play on it at the EDPB level. But when the culture of one of the member states is too different to be compatible with the European culture, there is the infringement procedure. And I think today about Ireland that we do not have any choice but the infringement procedure, because the Ireland will never want to comply with all those rules. And at least on the tax subject, Ireland tries to protect the tech giants. And on the data protection topic, I believe that it's more or less the same thing, that Ireland wants to protect those giants because of tax optimization and tax haven, maybe because of data protection haven.
Mm-hmm. We can take the next question.
Yes, hello, afternoon. Thank you so much for the interesting discussions from both speakers and also the moderator. My name is Elsbeth Beumer. I'm leading the International Investigation Department of the Dutch DPA. And I'm very positive about the one-stop shop mechanism. And I truly don't say that because in my capacity of head of the International Investigation Department, in which I'm dealing with cross-border cases on a daily basis, but because I truly see a huge improvement in the last years how we collaborate in the case handling. And so now I'm going to lift a little bit this black box for you to explain in what kind of cases, daily cases, I see this huge improvement. I see that the moment that we receive a complaint from another DPA, from the CSA, as we call them, I see that nowadays the files that they transfer to us, that they are complete. The complaint itself is translated, of course. Most of the cases, they are pre-vetted. That means that they already contacted the controller sometimes. They make sure that the evidence of the complainant itself is complete, that they include also the correspondence between the complainant and the controller. So the moment that as an LSA you get your file, it's a very complete and accurate file that you receive. Then the next step is that you start, as an LSA, you start with the case handling. And doing the case handling, on several occasions, you exchange via voluntary mutual assistance request relevant information about the case. It can be that you send updates on a regular basis, but also if you are doubting about the legal interpretation of the fact, or whether you're not sure you're asking the right questions to the controller, you ask the CSAs, hey, can you give this a look? What do you think about this? Are we in the right direction? Is the scope of our investigation correct? Then before we actually, at the end of the day, we come to a final draft decision in light of Article 60, we also sometimes, in big cases, exchange already our findings via an informal consultation. So again, we give an opportunity to all the CSAs to respond to our findings and give feedback on that. So I don't say that it always goes well. For sure, in my backlog of thousands of cases, for sure there is a case that we didn't do correctly or we're not very up to date or something like that. But I see that the frequency and of the context that the CSAs and the LSA have with each other, in combination with the files that we receive, I think there has been already a huge improvement. And that combined with the ambitious that during the Vienna Declaration has been agreed on, I'm really sure that we are going to see some very huge improvements also in the next years. So thank you again, but I wanted to align this. Thank you.
Thank you for this positive note. We take one last question, and we need to finish in 1 minute, so please make it very brief so that we can get some air and some lunch.
Thank you for this panel. I have one short question. The Vienna Declaration. What has been decided and what will change?
Anna, would you like to tackle this one?
Thank you. There were various different points which the Vienna Declaration touched upon. One of the, I would say, to name 3, maybe the most important ones. One of them was to identify the strategically important cases and decide and set an action plan also how to work on the strategically important cases. And this was one. The other one was to expand the way of joint enforcement actions, the type of actions that we took now this year when it came to data transfers on public sector, to have similar joint enforcement actions from the different DPAs. And as a third point, I would like to mention that it initiated that there should be EU level regulation on administrative procedural rules. These are maybe the three most important ones which I would mention here.
Thank you. I will just give the opportunity to Bastien and Maria also to add one sentence before we close, if you want to, leave the audience with some key takeaway that you saw in our discussion.
Okay, so thanks so much. It was a great panel and great discussion. Thanks all for the comments. So maybe I just want to summarize it, going back to our research, that we need, at least from side of data subjects and the academics, and I think also NGOs, more transparency from the side of the DPAs. So thanks so much for this excellent input on how one-stop shop work. It would be also great for us to know it and have just the place where we can find information, how, like, not calling it a black box, just knowing how it works in practice and when I file a complaint, what happens next, what are the steps. So more clarity and transparency would be really great to have. Yeah, thanks.
Thank you. Bastien?
Yes, to conclude, I think that we do not have to forget that we are talking about fundamental rights, right to privacy and to data protection. And we may have lost that the DPAs are kind of jurisdiction, and we have to enforce the GDPR because it's about fundamental rights. And today, when we have a procedure that lasts 3, 4 or more years, it's not acceptable because the other possibility is to go before jurisdictions and it's not as easy as it may appear. Actually, in France at least, it's very difficult, and La Quadrature du Net regularly filed complaints before administrative jurisdictions, and it's a lot of work. More work than before the CNIL. So we do not have to forget that a DPA might be a kind of jurisdiction because we are talking about fundamental rights. And today, member states seem to forget that point.
Thank you. And I'm sure a lot of the themes that we've touched on briefly here will be explored in other panels as well. There is a one on EDPB specifically, right? So if you're interested in this topic, please go check it out and enjoy the rest of your conference. And let's join me in thanking our speakers.